So if equity is not law, but that's what they're using against you, how and why? Well, because equity got its start when trusts came into popular use, and it was called chancery specifically. And it was a way to, they had to, because they couldn't use courts of law to enforce all of the arbitrary regulations on the property. So they had to have some other way to compel trustees to follow the rules that were set according to the trust instrument and trust arrangement regarding the use of property. So if the trustee was not using the property properly, that's what chancery is, what it was originally called. It's now equity. Chancery was for. I'll even show you. We've got this practical treatise on the law of trust from the 1800s, right? And this guy will tell you. It says originally, well, first I'll tell you, right, the origin of trusts, or rather the adaptation of them to the English law, may be traced to the ingenuity of fraud. By the interposition of a trustee, the debtor thought to withdraw his property out of the reach of his creditor, the freeholder to intercept the fruits of tenure from the lord, of whom the lands were held, and the body ecclesiastic to evade restrictions directed against the growing wealth of the church by the statutes of mortmain. What they neglect to mention is that for the rulers, it gave them the ability to create arbitrary rules and regulations and enforce them on everybody as if it's law. That's the biggest thing. And against their property. To be able to, this created a system of usury of property. But back to equity, what I was talking about there. It says originally, the only pledge for the due execution of the trust was the faith and integrity of the trustee. But the mere feeling of honor, proving as was likely when opposed to self-interest, and extremely precarious security, meaning, yeah, people's words don't mean shit when they stand to profit off screwing you over. So he's saying to make sure that trustees use the property the way that the owner, or they call beneficial proprietor, tells them to through the trust instrument. It says John Waltham, Bishop of Salisbury, a chancellor in the reign of Richard II, originated the writ of subpoena, which is now called summons. Subpoena was only when you still had some access to law and you were considered somewhat alive to the law, but now you're entirely dead to the law after the United States became insolvent in the 70s, and they finished setting up their entire commercial equity system, their trust indenture system. There's even an enactment called the Trust Indenture Act of 1939 that lays out, it's basically the groundwork, or the framework, the foundation of all of the regulatory policies, such as the Motor Vehicle Code. So, something interesting. But anyways, it says the writ of subpoena, by which the